When and how is the Defense of Marriage Act going to come before the United States Supreme Court? That was the big question following a U.S. Court of Appeals decision ruling that DOMA, which says that marriage must be between a man and a woman, discriminates against gay and lesbian couples. The ruling is the second by an appeals court that found the DOMA law unconstitutional.
I think now that we have two circuits that have found the Defense of Marriage Act unconstitutional, but on different theories, that increases the pressure on the Supreme Court to take this case.
And I think when you have this many federal courts striking down a major federal statute, it's exceedingly unlikely that the Supreme Court would not take one of those cases and sort of issue a final ruling.
The U.S. Court of Appeals for the Second Circuit said that Section 3 of the Act violates the Equal Protection Clause. The court said an 83-year-old woman was entitled to the same tax benefits as other married couples upon the death of her spouse, even though they were the same sex.
It's an elderly woman who claims that the federal government owes her several $100,000 because the federal government did not recognize her same-sex marriage, which was valid in New York, where she is a resident. And she's in her 80s, and she's, wants this resolved before she dies.
Significantly, the appeals court included an important new interpretation of its ruling. It said laws discriminating on the basis of sexual orientation must have a higher level of constitutional scrutiny.
And that's something that no federal appellate court has ever held before and is a really significant doctrinal development. So laws that draw distinctions between citizens on the basis of race and sex have long since received some degree of heightened constitutional scrutiny. Laws that discriminate on the basis of sexual orientation have not. So it's really a significant decision for that reason.
If the Supreme Court chooses to hear a case challenging DOMA, they could decide against it based on the Equal Protection Clause, just like the Court of Appeals. They could also look at the case through the lens of states' rights issues.
The main arguments against the Defense of Marriage Act, this part of the Defense of Marriage Act, come in two varieties. The first is an argument that this law distinguishes between citizens on the basis of sexual orientation without a sufficiently compelling justification.
That's the equal protection argument.
And the second is that this law undermines states' rights.
It's the federal government infringing on the state's prerogative to decide about marriage.
Whatever the key to overturning DOMA, Stein and Shaw agree that it's unlikely the court will decide on the constitutionality of same-sex marriage itself.
Now, I think that if the court takes the case, if it issues an opinion, everyone will be reading the opinion very closely to sort of see what the tea leaves say about the next case a few years or a few decades down the road that really does present the question of whether the Constitution permits states to limit marriage to opposite-sex couples. But I think it's really unlikely that it will be explicitly addressed in the decision.